Good morning. Welcome our February 7th, 2018 land use hearing. And first off, we'll call to order the meeting. I'll call to order the February 7th, 2018 public hearing to consider two separate application requests. Please join me in a pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we, well, see, it's sometime we're supposed to take a roll like that. No, like maybe that's later. Before we begin, I invite you, I already did that. Today we will further deliberate on the application by Pacific Northwest Solar LLC affecting property generally adjacent to Highway 26, Southeast Furwood Road, and Southeast Truble Road. This application was the subject of previous hearing by the Board of County Commissioners October 18, 2017. The application before us consists of two separate requests. One, a reasoned exception to Statewide Planning Goal 3, and two, a conditional use permit for the construction operation of photovoltaic solar power generation facility, approximately 70 to 80 acres of land that is zoned exclusive farm use. The hearing today will proceed as following. We'll first hear a brief staff presentation from Assistant County Counsel Nate Boderman. Doesn't introduce anybody. Oh, okay. I guess that's what we're doing first. Go ahead, Nate.
All right, I'm going to go and actually do a bias statement first, since this is a reopening of the hearing. And so I'll ask each of the commissioners to disclose any ex parte contacts, bias, conflicts of interest, or other circumstance that may preclude you from participating in this decision or might otherwise impair your ability to make a fair and informed and impartial decision in this matter. If you do have any conflicts you'd like to disclose, please indicate the nature of those conflicts or bias and indicate whether you intend to participate in this decision this morning.
Any issues?
I don't have a conflict or a bias or a conflict, but I think the state does, but we'll talk about that later.
Fair enough. And then I will note, we aren't taking any public testimony today, but if anybody in the audience wishes to challenge the impartiality of any commissioner, we will allow them to do so. Not seeing anybody indicating a willingness to do so, so I will go ahead and just jump into the staff presentation then. So as you indicated in the script, this is sort of a reopening of a hearing regarding a solar proposal or a solar facility for a proposal outside of the city of Sandy adjacent to Highway 26.
I'd like to, I missed something here. There will be no public testimony at this hearing. Assisting us today in the hearing is Clerk Kevin Moss, Senior Planner Martha Fritzie, and Assistant County Counsel Nate Boderman. And now we'll begin the staff presentation.
Fair enough. Fair enough. So this is effectively the third time that this matter is before you. The first time, as was indicated earlier in the script, was in October of last year, so that was our initial land use hearing. That hearing resulted in a 3-1 vote with one abstention to approve the solar facility at that time. And as part of our land use hearings, when you approve an application, what you also do is you direct staff to draft findings and bring them back to you at a later business meeting. So that was the second time that this was before you, was a later business meeting in November to actually adopt the approval findings. What happened between the time that you made your oral decision in October and the time it was that we had set aside for you to adopt the findings in November is that LUBA made a decision, the Land Use Board of Appeals made a decision in a similarly situated case out of Jackson County dealing with a large-scale solar facility. LUBA issued the decision in late October, and what it effectively did was undermine much of the justifications that we had used in the findings before you to support the approval. So Jackson County had a similar large-scale solar facility that was under consideration. And once again, when we draft the findings, we have our legal interpretations that we work through, essentially working through all of the criteria. And the result of the LUBA decision, once again, undermined many of these justifications that we had used. So at the time of the November hearing, the board voted 2-2 to open this matter back up and to reconsider this in light of the LUBA decision. You wanted further explanation of the Jackson County decision, and so I provided a memo to you. Hopefully you had a chance to read through that. But I'll note at the time of the initial hearing in October, you did hear some arguments and some testimony surrounding many of the legal issues that were subject to not only this matter, but also the Jackson County matter. The LUBA case effectively took on those legal issues head on. At the time of our October hearing, we really didn't have any guidance. Many of these were issues of first impression. And so we now have the benefit of the Jackson County case, and for better or worse, it doesn't necessarily support a finding of approval in this matter. We'll go ahead and discuss what some of those legal and policy considerations are. Certainly happy to answer any questions that you might have, but just wanted to get that out sort of at the front end. So as I mentioned, I did provide the memo, highlights many of the specifics regarding the legal interpretation issues that are at issue in both this case and the Jackson County case. As it stands, in my opinion, from a purely legal standpoint, again, if this matter were to be approved and were to go up on appeal, I don't think it stands a good chance of being supported on appeal. I will note that the Court of Appeals currently has the Jackson County matter before them, and so there are open questions still. I'm not sure of the timing of the Court of Appeals decision and whether that would be resolved in any timeline over the next couple months, over the next year. The Court of Appeals has a fairly loaded docket, and we've seen in the past that these things can take months, if not a year, to sometimes work their way through that process. So I guess I'll conclude by noting that the state of the law for the siting of solar facilities is certainly in flux. Again, we're waiting for the Court of Appeals to resolve the Jackson County appeal. As a result of the LUBA decision, I'm not sure if there's any path forward or any viable way to site these solar facilities, these large-scale solar facilities, I should say, on EFU land, and I'm not aware of any legislation or any pending rulemaking to address that particular issue. What I've also done, in addition to sort of the legal analysis in the memo, is highlighted a number of policy considerations because it's become clear to me that this board is certainly supportive in theory of siting solar facilities, but also are concerned about preserving viable agricultural land. And so there's a conflict there. There's a prioritization that has occurred as you work through sort of resolving those competing state interests and competing local interests, frankly. So that's really the crux of the issue. So in addition to the legal opinion, I've also provided some policy considerations that sort of highlight some of the differences between the property at issue in Jackson County and the property at issue here in Clackamas County, that if you were inclined to move forward with an approval, I think there are some legitimate policy considerations that could support an approval as well. So with that, happy to answer any questions that you may have. I know it's not so much talking out both sides of my mouth on that one, but certainly there are, this is still an emerging issue, and we're going to be seeing more of these solar facilities. And so I think the legal conversation is certainly relevant, but I think there are emerging policy issues that are worthy of consideration as well.
Okay, Commissioner Savas.
So, yeah, it puts us all in a very difficult position trying to understand what the state's looking for, and I think the state's predominantly EFU land and forest land, right? So I don't think no one wants to cut all the trees down to put solar panels on, and apparently we don't want to put them on farmland. So what's left? And yet we have a state that wants to, is discussing, the legislature's discussing cap and trade issues to limit carbon, which means we need to look for alternative sources for energy, that's what solar is. And so we're conflicted in so many ways. So all to say, really, I mean, without really going on endlessly about this, My question is, what are our options today? Because of all this indecisiveness with lack of clarity, can we defer this until there's clarity? What does the applicant want to do? Those are basically two things I'm asking.
Good question. So as I see it, there are 4 options. You could approve, you could approve with modifications to the Planning Commission's recommendation, you could deny the application, or you could defer a decision to a later date. There are no state statutory timelines to make this decision. Normally, we're either under a 120 or 150-day deadline, depending on the nature of the application. That doesn't apply here because the statewide planning goal, we're taking an exception to the statewide planning goal, so that is exempted from that timeline requirement. So to your point more specifically, you would be able to defer this decision in a way that you normally aren't other land use decisions. Last time I spoke to the applicant was probably a month or so ago. They are pushing forward with another solar application that's on appeal. This is, as far as I know, there are 2 projects that are in Clackamas County. Both have raised questions from the state. One went before it. It was one out of Estacade off of Deuce Road. You approved that last fall, I believe, and that was appealed by DLCD. So we are working through that process as we speak. I would anticipate that the state would probably appeal this one if it were approved as well. I don't know that for sure. But the applicant has expressed a desire to go forward. They've also expressed a desire, if the board were to approve this, to defend the appeal. It's not uncommon for applicants to carry the water, so to speak, on appeal, since they're really the party in interest. And as long as there aren't any procedural issues or questions regarding our process or substantive county policy at issue, more often than not, we're happy to let them participate in that way. So that's what I know about the applicant. Many of the policy reasons that I outlined in the memo are reasons that they raised at the initial hearing as to why this proposal is different from the Jackson County proposal. Again, you have high-value soils in Jackson County. You have low-value soils predominantly on this property, and so I think that's one meaningful distinction, if not meaningful for the criteria, meaningful from a policy standpoint. But again, to answer your question more directly, the applicant desires to go forward. They've indicated a willingness to step up and carry the water on the appeal, and that's where I've left it with them.
Okay, Ken?
Yeah. Well, when we first made our decision on this, we knew about the Jackson County case that had already gone to court. I realize they've made a decision since that time, and it's now at appeal. But what we get paid for is to make value judgments. That's a big part of our job, and to balance competing values on occasion. And that's exactly what I see here, is competing values. The difference is that we're talking about low quality soils, demonstrably so. Two farmers have failed in those soils. That's the bottom line here. We're not asking to, and the applicant is not asking to do something on high quality farmland, which I think would be a disqualifying factor in my mind. My opinion is this is no cost to us, and in the final analysis, the court is going to clear this up one way or the other. I believe that we should go ahead and affirm the decision that we originally made, support the applicant's application based on the arguments that we made the last time around. If the court says, hey, they're okay, then the applicant can go to work without having to come back to us and spend more time at another hearing. If the court says, nope, can't do it, the reasons don't apply, then they're done. But it seems to me that the burden at this point is now on the court to make the decision. So we should just affirm what we already decided and let the court make its decision. And essentially, we're off the hook, is the way I see it, one way or the other. But in the final analysis, we're going to have these kinds of decisions where we have to have competing value judgments that we're going to have to weigh. And if we're going to have more renewable energy, then we're going to have to look at things such as marginal farmland and say maybe this is a better use for that marginal farmland than having more farmers fail on the same land, or just letting it sit there to no purpose. So I would move to, well, I won't make a motion at this point in time, but I would say that I would support continuing to go forward with the application as we already did. Thank you.
Commissioner Fisher?
Yeah, I just had a question, because I was out there when I went on my tour of the Forwood Community Planning Organization. I saw the site, and it has an active tree farm on it, and so although the soils might be considered not as good as other soils, I don't know, and the farmer might not be able to make as much money as they want. I don't have knowledge that it's farmers that have failed.
According to the farmer, the problem is the soils lend itself to root rot. And so the trees are not doing well on the property. That's one of the reasons it's failing. And the prior farmer was a strawberry farmer, and it also failed.
Yeah, that was part of the conversation in the hearing. Those two issues.
Yeah.
The only thing I'll add to that, I agree with what Commissioner Humberston said as far as making those value judgments. That's our job. What's different here is the goalposts seem to be moving, and now they're invisible because we don't know where the goalposts are. So I think we all want to do the right thing, and we don't know what the right thing is.
Let the court decide for us. In the meantime, if the court decides in favor of the applicant, they can move forward. If the court decides against the applicant, it's dead in the water.
I appreciate Commissioner Fisher bringing up that issue, but yeah, as I recall, the carve out on this, where they're going to put this on this gentleman's property, is specifically soils that are compromised and they can't do anything with. So it seems to be ideal in the sense that, absent, any other alternative on this property or some other kind of farming use would work on that, other than putting structures on it, I just don't see. And, this is kind of along the lines of renewable energy. So it's a conundrum.
Any other comments or questions? Yes, Commissioner Schrader.
I'd be willing to move forward because the difference here is it's low-value farmland. And maybe that will shed another piece to this. I fully expect it to be appealed to LUBA. But I think that we are looking at, I think it will shed light on the conflicting values, as Ken says, and that'll help clarify longer term, where where the state's going to go with this. And it may be that the solar energy piece is not going to be those larger acreages, but the smaller arrays, on rooftops and things of that sort that, wouldn't really, I don't think, again, when you look at energy logistics and energy creation, would necessarily give energy to the larger grid, but it would be more localized, more, help certain houses to keep their energy costs down, that kind of thing. So I think it's a worthwhile policy piece, just to see where it lands. I'm okay with that.
Thank you. So my whole frame, probably my entire life, has been least amount of emotional and financial stress possible. And what I would suggest is us deferring to see what the Court of Appeals does, which will provide more framework and more guidance, because this issue is so much bigger than this piece of land, these soils, this solar project. It's much bigger, it's much broader. We have to find ways to have renewable energy, and we have to figure out as a state, within the construct of our land use laws, how we're going to do that responsibly. And as for me, I think solar panels should be everywhere because we need renewable energy. And I've just had the honor and the privilege of visiting places all over our county, and in some of our agricultural land, there are solar panels, right on houses. And I went to one home where they were cooking their dinner in a solar oven in the yard. We are transitioning, we are moving to renewable energy, but I am just not comfortable with us making that decision to place this solar farm on this farmland. And probably it's just a gut feeling of being there and seeing how it didn't look like the trees were rotting to me. It looked like there were some pretty nice trees there. I didn't take a direct tour. I just met with the people that live in the community. saw the land and appreciated the land. I've also been out to see the other solar site that we did approve, and I don't know if you have seen that, but you go through farmland, beautiful, beautiful farmland, and then all of a sudden it's under construction. It is just mass. It also destroys the landscape. So, and that was on higher value farmland that this board approved.
When did we do that?
That was the first one.
That was the first one.
No, that's not, that was also,
Appealed.
that was also a piece of land that had some difficulties because there was water and wetland aspects to that piece of property.
It was
So
a
it hadn't been
higher
farmed,
value.
that had not been farmed in 70 years.
I don't think that was the Deuce Road site, but there are some other solar projects
Yeah,
under,
I might have seen another solar project.
Under
But
construction as far as
all
I
I'm saying is that the ramifications are so much broader than this, and I would advocate waiting until the Court of Appeals weighs in so we have more construct. I don't like to see people having to prepare, having to litigate, having to do petitions. I don't like to have our staff participating because we make a decision. It does take our time and energy away. I don't want to see us participate in unnecessary appeals if we don't have to, and I think this is one that we can wait for further guidance.
And in that case, we would vote to table it.
Well, one thing that, and Nate answered my question with regard to what does the applicant want to do, and I think it would be, if the applicant wants to have us move forward with this, knowing it's going to be appealed, in turn, they'll have two cases before the court and say, okay, we've done it here on two different properties with two different soil situations, and it might help the argument, actually, and help LUBA or whoever it may be gather around the policy and the rationale as to what the guidance is. So it might actually turn out to be leverage, which can be used in the essence for them to get better clarity. So is that viable, or
possible.
can they actually weigh this particular case if it's really on hold, if we just table it?
well, if we tabled it, then LUBA wouldn't have jurisdiction to hear the case. It would remain with the county until a time that you made a final decision. At that point, then anybody would have 21 days to appeal that to LUBA. And so as far as considering other companion cases, this wouldn't be eligible for any sort of consolidation, so I don't know if LUBA would look outside of the current record in front of them to make any sort of determinations about the merits of one versus the other. But to your point, there may be some economies of scale as far as preparing the legal arguments, since the legal arguments are similar across the board. But as far as leverage on the body making the decision, probably not a whole lot there.
Is the applicant here?
No,
No?
no.
Okay.
I believe the property owner is here.
The problem, you can't really open it up and ask for testimony because then we didn't notice that we were having testimony, so that would be a problem.
That's correct.
Would it be a problem to ask the owner, you or one of your staff to ask the owner what they want to do?
Well, what's your question? We might be able to answer, and if not, we can always provide some correspondence after. And keep in mind that if you approve or deny this today, we'll come back to you at a business meeting with findings supporting whatever decision you make. And I realize that it might be sort of out of order, but you would have an opportunity for somebody to make some comments to you, potentially at that point. Again, may perhaps be out of order, but if you really had questions prior to your decision, perhaps we could answer those.
Okay. The only reason I asked that question was to, in case somebody wanted to ask the question, not necessarily me. Ken?
Yeah, I'd just point out that the legal case is already going forward. It isn't as if it's a new legal case or anything like that. So, again, I simply say that the reasons that we originally affirmed the decision still hold. I see no reason to change it because the circumstances haven't changed. It's still in court, and the court will make a final decision that will either say, yes, you can go forward, or no, you cannot go forward. So If they say, yes, you can go forward, then he doesn't have to come back here and ask us again. And if they say, no, you can't go forward, he doesn't have to come back here and hear us tell him no again. So it just seems to me the most expeditious way of handling this, the most rational way of handling it, is to simply affirm our original decision, let the court decide what is going to happen, and move on from there.
One question is, one of the issues was the size, 70 to 80 acres. Do you know what the size is where you don't have to go through this process?
12 acres.
Oh, 12.
It depends on the soil types.
It depends on the soil type.
So you could have seen a 12-acre site near there,
Yeah, maybe.
maybe?
I'm just saying, it does change the landscape dramatically, and as the Board of County Commissioners or the land use, the judges for land use, that should be one of our considerations as well.
Paul?
Well, yeah, I don't disagree with that, but it really is a policy question. Getting back to the goals, state planning goals, our goals, I mean, that's the thing. Well, Dane, I hate to put you on the spot, but I'm going to put you on the spot. What do you recommend we do?
Well, again, as your legal counsel, I don't think that this is a particular, on appeal, I don't think it's a winner until we get any further clarification from Court of Appeals. I think the issues were squarely addressed by LUBA, and LUBA said that the justifications that we proposed to use to approve this were not valid. And so, under the current guidance that we have from LUBA, I don't see how this case is upheld on appeal. And so, again, from a legal perspective, I would recommend against approving it.
Okay.
So just my question is, so the notion of soil type wouldn't enter into it? Because again, it's a different, you're talking about high value versus
The
low
rules
value.
talk in terms of arable soils versus non-arable soils, which is different than the soil classifications, where you have low value soils versus high value soils. And so what we're typically used to talking about is the distinction between, the class 1 through 4 high value soils versus low value soils. And Martha can jump in and correct me at any time if I'm misspeaking or speaking out of turn here. But what the rule does is it talks about arable soils, which is almost a lower threshold, because arable soils are soils that are cultivated or capable of being cultivated, which could include low value soils.
Right, but it also has, when I hear arable, I also hear water. And evidently this site has a problem with
Irrigation plays
water.
into it as well, yeah.
So I'm kind of like, if there's a water issue, I would say it's pretty non-arable, but
So if I could jump in, the distinction that you're talking about, though, really has to do with the threshold that requires a goal exception versus not. And so we have a number of these smaller solar facilities going into the county on farmland and forest land that don't exceed that threshold anywhere from 10 to 20 acres, generally, depending on the zoning and the soil types. Those can just go in with a conditional use permit. They don't come in front of you. And the arable and non-arable conversation is really what makes a distinction of how large you can go before you have to do a goal exception and go through the process that this applicant is going through.
okay, thank you for that
So
clarification.
arable means, again, they have water rights, or they can, what's?
No, the definition in the administrative rule, and I have it in here, it has to do with having a history of cultivation. And so there's 3 categories. There's high-value soils, which line up nicely with what we consider high-value soils, class 1 and 2 soils. Then there's the arable versus non-arable. So if you don't have high-value soils, you're either arable or non-arable, and it really has to do, there's 2 factors. One is whether or not there's any history of cultivation, which of course there is on this particular piece. And then if your soils are so poor, if they're predominantly class 6, you don't even have to worry about if it was ever cultivated. That's considered non-arable.
Okay, well, that's helpful. Ken?
And the last thing I'd point out is the landowner owns a significantly larger chunk of property nearby that has decent soils and has made every indication that his intention is to continue to farm that land. So it's not, again, it's not as if we're taking really good soil, good land out of production. He intends to continue farming on his other parcels. So we're still retaining good soils for production in agriculture. That's all I have. Thank you.
Well, approving this case is not going to factor into or benefit the decision that Luba's making, I'm inclined to defer it. That's simple as that. I don't know what really else to do. I mean, I don't want this to come back, and I understand the anxiety of us, you know, and I know, like, we want to get this done. I don't want to get this done. I don't want to see this, but this it's out of our hands. It's going to come back anyhow. No matter what we do, it's going to come back.
So would we table it then?
Well, we could deny it, and it would not come back.
Yeah, I
Council
guess
decides.
two options, yeah, and I could modify, you know, my recommendation in that regard would be to either deny, which would end sort of the life of this application, or you could table this until perhaps the Court of Appeals made their decision, we get further guidance on sort of the state of these legal interpretations, which would continue this application. The applicant could always withdraw if they want. It puts more, I guess, control in the applicant's hands as far as what they would want to do, but you wouldn't have to have this come back before you until you chose to have it come back before you.
Okay, Commissioner Schrader,
I just wanted to clarify,
let's test it.
Commissioner Savas, so you're saying table it until we find out? what the
Table it
Court
till
of-
there's
of
more
Appeals.
guidance out of Luba.
More guidance out of Luba or the Court of Appeals? Well, that would be the compromise. I mean, I'm okay just throwing it out there and seeing where it goes, quite frankly, because I think that this has to be decided, and it's just another case.
Well,
But if tabling it until we find out what the Court of Appeals is going to do with that previous case, then we can discuss it again. I'm okay with that.
So let's throw out a motion and see what happens.
Mr. Chair, I move that we table this decision until we get guidance from the Court of Appeals and ask our attorney to bring it back to us at that time.
Second.
It's been moved and seconded that we table this appeal. Well, I don't need to read all that. Table. Any further discussion? So please take a roll.
All right. Commissioner Humbertson,
Opposed?
Commissioner Fisher,
Aye.
Commissioner Savas,
Aye.
Commissioner Schrader,
I'm going to compromise on this and say aye.
Chair Bernard.
No. So it's tabled.
Yes.
It's not exactly how I thought this was going to go.
Nor did I, actually.
So now we really don't need to, we're obviously not, so this has to still come to the meeting to table it, right?
What we'll do is, once the Court of Appeals decision has been made, I can prepare another memo or some kind of correspondence, let you know what the result of that decision is, schedule
Another one of these.
another one of these, and we'll go from there.
Okay.
And then the question is whether or not, again, it's tabled now, but even when we get the Court of Appeals, we can move forward if we choose to.
Correct.
Is that correct? Okay.
All right, with that, we will adjourn.
Perfect.